Greetings, everybody. This is Professor Hussein again with ASC 2320 Aviation Law and Regulations, Chapter 8. That's airline liability. We'll get into that. General principles of liability and risk management previously studied applied to U.S. airlines. Yeah, this liability and risk management priest applied to U.S. airline and the legal relationship with domestic passengers and higher duty of care, which is imposed upon them on those operations. Legal relationship between airline and international passengers, at least from the time international passengers begin the process of boarding the aircraft until she or he reached safe place within the terminal at her destination is governed by different and unique laws of bodies of law. This law includes new international treaty known as Montreal Convention that updates the old Warsaw Convention, which had already been modified by contracts known as Montreal Agreement for flight touching the United States. Uh, The purpose, obviously, is to acquaint ourselves with heightened legal responsibility of airlines and use of airline tariffs as risk management tool vis-a-vis domestic passengers, and also be able to enable to recognize and avoid mistakes that can deprive an airline of the protection afforded by international laws vis-a-vis international passengers. Airline liability to domestic passengers. We will define domestic passengers as airline passengers particular show origin and destination within the United States, whose planned route does not include any stops outside the U.S. When domestic passenger is injured, the first question that must be addressed is whether airline is acting as a common carrier, as operators commonly considered a common carrier if it represents to the public, either in writing, such as by advertising, or by course of conduct, that is, it will carry for hire at a uniform rate available to all persons applying for cargo presented, as long as these remain unused capacity in the aircraft. Liability to domestic passengers. Common carriage and contract carriage is controlling question as often the price paid for the trip is a standard price that is effect for class of service on the flight or is negotiated price. If a person paid an airline listed fare, for example, $400 round trip coach class from LA to New York, that looks like common carrier transaction. Airline fares schedules have become profoundly complex, computerized sliding scale designed to maximize revenue in each flight up to the moment the aircraft door closes. And although no case law has yet appeared on questions such as program would likely to be found to satisfy a uniform rate test. Less clear, also unaddressed by law, is situation posed by purchasing tickets. Such airline intermediaries as Travelocity, Priceline, whose advertisement at least gives the consumer's impression the company is haggling with other airline on behalf for the best prices. Two jetliners take off from Dallas, Texas, bound for college basketball tournament in Boise, Idaho. The first aircraft is airline operated by commercial airline The college basketball team and coaches are traveling on a regular fare ticket purchased for them by College Alumni Association. A few miles behind is an identical aircraft owned and operated by wealthy Texas oilman who is dedicated alumnus of the aircraft of the school and great fan of his sports team. Oilman has donated the use of aircraft to transport his alma mater basketball team and coaching team. The winds over Rocky Mountains were westerly and in excess of 30 knots, with wind velocity increasing with altitude. As two aircraft approaches the Rockies, both flight crew observed lens-shaped clouds over the mountains. Both aircraft experiencing smooth ride, and neither flight crew has illuminated the fasten seatbelt sign. Suddenly, aircraft encounters severe clear air turbulence that throws unrestrained passengers about the interior of the aircraft, injuring some. A moment later, same thing happens to the second aircraft. Injured passengers in both aircraft subsequently sue the aircraft operator for negligence. In separate trial of two accidents, airport expert aviation meteorologists testified these winds conditions would indicate probability of development of standing mountain wave along the eastern side of the Rockies. They would further testify the fact that such wave had already developed was confirmed by cruise observation of altocumulus standing lenticular clouds. Liability with international passengers is considered international passenger if that ticket shows that an origin in one country and destination in another country. Or number two, an origin and destination in one country but planned intermediate stop in a different country. Warsaw Treaty states that the states agreed that this would be best accomplished by adopting an international treaty that would protect international airlines from catastrophic loss in the event of crash, promote airline safety. Number three, promote availability of liability insurance to international airlines, provide uniformity of terms and conditions of transportation by air. Number five, with those of other modes of transportation, ship, rail, bus, etc. And number five, provide a framework of international uniform law to govern international airline crashes. Thus, as most legislation and treaties, compromise were reached between competing interests. In this final form, the treaty accomplished the following. The framework of an internationally uniform law was established. Treaty provisions standardized claims procedures in the event of international airline crashes. These procedures provide internationally uniform answers to these questions. Number one, A, in what nation's course way a lawsuit arise out of crash B, brought, and number B, what nation's law governs crash, choice of law, and C, when must the lawsuit be filed or forever barred, statute of limitations. The treaty provided that international passengers can choose between four possible nations in which to bring lawsuit for injury: nation domicile of the airline, nation in which the ticket was brought from airline from travel agent. Number four, the passengers nation, the passenger's destination, except where purpose provision of treaty apply. The forum court, the court's nation was applied and being tried, applies its own choice of laws, ruling, deciding what laws it governs the litigation. In 1929, there were a number of other international conferences resulting in several treaties that changed some aspects of Warsaw Convention between those nations, including from the time raising onerous limits of recovery, personal injuries, or death. But opposition in the United States, spearheaded by ATLA, long prevented the United States from signing any of the subsequent treaties. By 1965, opposition reached out some proportions that the U.S. declared its intent to withdraw from Warsaw Convention. and to consider its prior grant of landing rights in the U.S. to airlines or other aviation unless those international airlines serving the U.S. would sign a contract with the U.S. government raising the limits of those airlines' liability for passengers, injuries, or or death. The airlines met with representatives of the U.S. government in neutral territory in Montreal, home of ICAO, where they entered into Montreal Agreement, a contract between airlines and the U.S. government. Airline agreed to increase the ceiling of liability for injuries and death of passengers to $75,000 for international flights touching the United States, originating, terminating, or in having agreed stopping place in the U.S., regardless of nationality of passengers. International airlines wishing to subsequently enter the U.S. market were required to sign Montreal Agreement as a condition precedent to such service. Liability for international cargo was generally liable under Warsaw Convention for loss of destruction of cargo to a maximum of $16.50 per kilogram. These were our five defenses to cargo claims that airlines were permitted to use defeat even that liability did not change any of the Warsaw's provisions regarding cargo liability. These five defenses to international cargo claims were: airline took all possible measures to prevent cargo losses. Number two, pilot or navigation error caused the cargo damage. Number three, shippers contributed negligence caused the damage to cargo. And number four, loss of damage or destruction of cargo was caused by act of God, war, or state. And number five, nature of goods caused the damage. Shippers' contributory negligence. This defense could have been applied if shipment was, for example, a rare, precarious, precious accident. Ancient waste from China Ming Dynasty was merely shipped in a crate without sufficient internal energy absorbing material to prevent breakage. Act of God, war, or state. This defense is applied if causes of loss, damage, or destruction of cargo was a major force of nature or for example, aircraft was picked up from the ramp by a tornado, scattered the cargo to the wind, or was shut down or blown up in the course of war, was seized by government agents. Warsaw Convention required the airline to deliver passengers physical paper tickets to the ship or cargo waybills, placing the customer on notice that a provision of that treaty, as amended by Montreal Agreement, applied to the flight. Airline was required to give the notice in a timely fashion, allowing the customer the opportunity to take other measures to protect herself from losses, as purchasing additional insurance. Attacking the inadequacy of actual notice given to a passenger prior to a particular accident flight became a favorite technique used by plaintiff lawyers to attempt to break the merger limit of liability. Montreal Convention 1999, modernizing Warsaw, accomplished its objective. Admittingly, sometimes it's considered costly cost to injure international passengers, travelers, and survivors. Liability insurance is now readily available to international passengers, protecting them from catastrophic loss. Travel agents, shipping clerks, customers now routinely easily book air transportation for passengers, rate moving more so now than any other mode of transportation. By its provision, the treaty would not take effect until 30 nations ratified it. This finally occurred in September 2003, with the US being the 13th ratifying nation. As in the past, many nations awaited ratification by the US before making ratification decisions, since the U.S. refusal to agree to either of efforts to amend Warsaw had rendered these international efforts largely wasted. Once U.S. ratified the treaty, the ratification flows quickly through other nations, so the Montreal Convention can now be considered universal. This is it for chapter 8. We shall continue with other chapters next week. Thank you. Have a great day. Anytime you have questions concerning anything, please email me, text me, or call me. Thank you. Have a